Yes, I know some of your names, and I don't know all of your names, so I'm going to point at everybody to be equal.
This panel is composed by 4 eminent jurists of 3 major common law countries. And it is from a European viewpoint, it is curious to see how the common law systems coincide, that the treaties that the countries ratify are not directly applicable. In Europe, after the Weimar Constitution in Germany of 1919, it is considered that generally recognized principles of international law are part of the federal law and therefore directly applicable. And so the Constitution in Spain or the Constitution in France and even the Constitution in Holland, if I remember correctly, says that treaties are even above the Constitution itself. So how would you consider this, let's say, continental European position of accepting this monist attitude vis-a-vis what you have explained from a common law viewpoint?
John?
Well, I think you're talking about a position that prevailed many years ago. In some common law countries, the situation has changed dramatically. For instance, in the case of South Africa, we have a constitution which actually directs the court to apply customary international law and to makes provision for the incorporation of treaties and obliges courts to interpret the law in accordance with international law. And South Africa is not unique in this respect. One finds that much the same has happened in England. It refers to the European Court, the European Convention of Human Rights is guided by it. I think it's true to say that the sharp distinction that did prevail between the civil law and the common law countries in respect of international human rights standards is no longer so sharp. I think that common law countries do invoke international human rights standards to a much greater degree. I think in the United States it perhaps a bit backward in this respect.
Could I just try to explain the fundamental basis of the common law position? It was that the executive government, the Crown or the President, negotiates and signs treaties, and that the lawmaker is the Parliament elected by the people, and therefore unless the Parliament elected by the people gives effect to a treaty, it's simply something the executive has done. And one of the great constitutional battles in the common law world was between the Crown and the Parliament, and this is how it developed. But the mistake that was made was that it wasn't fully realised until Bangalore that whilst Parliament is the main lawmaker, judges also have a role in making and developing the law. It can't be a matter of incorporating a treaty by the back door, as it's often said, but it can be a part of developing legal doctrine within the country by reference to the contemporaneous developments that are happening. So it wasn't entirely an unreasoned position of the common law. It was a position defensive of the elected parliaments, which were always very strong in common law countries. And what we've seen now is that the role of the judges has been enhanced. And I must pay a tribute here to Robert Post and the Yale Law School for organising every year a great conference of judges of constitutional courts all around the world for, as it were, telling them, as Justice Chaskalson said, the same things are happening all over the world at roughly the same time, so we can learn from each other. And I would hope for this law school, with Professor Bergenthal now returning home, as he said when he came back here, that it will also play a real leadership role in the United States of America, which, like my own country, is about the last resistant bastion of the old doctrine, so that judges realise they too have a role. It's not the great lawmaking role of parliaments, because we don't have the democratic legitimacy, but it is a role of developing legal doctrine, including, as the High Court of Australia did, in the field of Indigenous peoples law.
Tim, you want to add anything?
Well, yes, but it won't really be much of an addition. One of the troubles in the United States about this position, as it's held, is that the State Department, the Legal Advisor's Office, in determining whether to support an international instrument, or whether to ratify or sign an international instrument, generally speaking, will make a review to determine whether that instrument is entirely consistent with the already existing United States law. Well, good heavens. That would mean once it's adopted, supported, or signed, it would have no effect at all. And that's really not appropriate in the case of human rights instruments, especially where indigenous peoples are concerned, because change is needed. And if they go about refusing to adopt anything or recognize anything that doesn't merely ratify existing law, well, that's quite contrary to the whole idea.
I think we're beginning to run out of time, but yes, we have a question there.
I make a question, an issue to the panel regarding Roma rights. As we all know, President Sarkozy has agreed to the expulsion of Romas from France. Some of the other governments of the European Union differ from the position that's taken in France. The Minister of the Interior of the current but mortal Italian government has also supported Sarkozy's position. This matter may become a justiciable matter, so to say, under the sort of immigration rules of the European Union countries. But it may also become a justiciable matter, and this is where we'd like to have the view of the panel under the what's called the human rights laws. And it may also develop into a conflict between laws in the positive sense, word, and human rights principles.
I can respond at least in part. I hesitate to respond with reference to the facts because I don't know enough of them, and that I should not respond about the facts in particular. However, I can point out that the Declaration on the Rights of Indigenous Peoples, for the first time in an extensive way, recognized that groups or collectivities or peoples have rights in international law. Now, many countries were perfectly willing to call those human rights. Other countries, and some scholars, don't like to call them human rights, but they all agree that they are actual legal rights in international law, and they've now been extensively recognized in this one document. And in principle, they should be recognized much more widely. That may be of some help. Rights against discrimination, of course, against the whole people, rights of against discriminatory treatment, even some rights of self-determination for peoples within countries, and so on. I think there's no question that these actions at least implicate international human rights issues, and we'll see whether the advocates take up those kinds of arguments. I hope they do. John?
I think we must face the fact that immigration has become a major issue in European countries today. And it's not only the Romas that are threatened, but there are political parties in a number of European countries, including the Netherlands and China, where Muslim people are under threat as well. So I think we have to face the fact that there is likely to be a confrontation between governments and the European Court of Human Rights on issues relating to discrimination in the application of immigration laws. And one simply hopes that the European legal order will prevail and that discrimination of this kind will be resisted.
Michael.
As you would know, the common first article to the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights refers to the people's right to self-determination. And of course the question then is, who are a people? And part of the reason for the former government of Australia resisting signature of the Indigenous Peoples Convention was a fear that that might endorse the notion that Aboriginal people in Australia or Torres Strait Islanders could exercise self-determination as against the rest of the country. But what isn't fully realised by some of the critics is that self-determination can take many forms. It doesn't mean necessarily, and in many cases it won't mean, complete national independence. It merely means fulfilling yourself, and fulfilling yourself by institutions, by language, by culture, and so on. The former government of Australia refused to sign and indeed voted against. It was interesting. Those who voted against it were New Zealand, a wonderful country and a very enlightened country that has treated its Maori people the best of any of the settler societies. The United States, Australia, and Canada. I mean, three rather good countries in terms of the way things normally happen, but they voted against them. Australia had a change of government, a big change of government, and the new government announced that it was going to ratify the convention. It hasn't done so yet, and of course it's been re-elected with a knife-edge majority, so it'll be interesting to see whether they do. But I expect Australia will ratify the convention.
Well, because of the question, I'm going to broaden the panel because we actually have an expert on that, just sitting there at this table from the Roma Rights Centre. And perhaps, Robert, you might just like to respond to that question. And can I just get an indication? I know there's strict time. Can you tell me whether we're finished, whether we've got any extra time we can claim? After.
This is it.
Right, well, you've got the grand finale.
Better make it good. I mean, I think that the issue of Roma expulsions in Europe very much illustrates the interplay between law and politics here, because on the one hand, what France has done in declaring a law enforcement and migration policy explicitly along ethnic lines, as the President of France and the Interior Ministry have done in written documents, is clearly a violation of international law. On the other hand, the French government has assessed the political cost of violating international law in this regard and decided that it's an acceptable one, and weighing domestic politics as well. And if you look at the broader set of European human rights institutions, we see this similar issue, that you have, on the one hand, very well-developed set of international institutions, and the European Court of Human Rights is one of the premier adjudicatory mechanisms for international human rights laws expressed in the European Convention. On the other hand, enforcement and implementation of European court decisions leaves a lot to be desired. And essentially, European states frequently decide that it is part of the cost of doing business, of violating rights, to lose a case, to pay some very small money judgment to victims, and then to continue violating rights as they have before. And we see this certainly in the Roma rights context, where you have 3 decisions of the European Court finding that segregation of Romani children in schools constitutes illegal discrimination. But in all 3 cases, the governments concerned have paid off the small sums to the victims and continued segregating their schools. And France, I think we have a similar situation where France is, they're prepared to bear the political cost of the violation and continue behaving as they have.
Thank you. I'm sorry we've run out of time. It's a great pity because I think that we're getting on the brink of a very, very interesting discussion. But I'm subject to the rules. I've got no discretion to extend the time. With much thanks, and really it's just an opportunity to hear our laureates in action. I think you've heard them, you know who they are, and Thank you all very much, and thank you for the questions that we've had. And thank you again to the Gruber Foundation for the occasion, for the prize ceremony, and for choosing such three splendid people.
Thank you all for joining us, and this does conclude our program. Thank you.